Greetings and welcome back. We're here for Chapter 9. Now we're going to start getting into some really cool stuff, I think. You really enjoy probably what we go through from here on to the rest of the chapter. Everything was kind of foundational as it relates to what you're thinking about getting into in your career and probably also what you've already heard. It's the first time we're going to get into some really deep area of law stuff, and then we're going to move away from this into more constitutional law stuff. We're going to get a little more into the rules of evidence here today. Today is hearsay. Hearsay and its exceptions. And everybody here should, kind of generally know what hearsay is. He said, she said. Right? That's what hearsay is. The general rule is we're not liking it. We don't like it. It's not allowed in court. That's the general rule. So what's the basic definition of it? What's the basic rule? The basic rule is that hearsay is not allowed. And hearsay is defined as a statement made by a declarant out of court that is admitted into court for the truth of a matter asserted therein. Now, what does all that mean? Well, a statement, it really is anything. It's really more like an assertion. It's a response. It's something by a human being. It can't be an animal or a machine. It has to be a human being. It can be verbal, nonverbal, and it could be in writing. Now you're probably wondering, what's this nonverbal? If whatever it is you're trying to bring in was intended to express something, it's a statement. For example, if someone came in from outside, they had an umbrella, and they looked really wet, and you said, man, it looks really wet outside, was it raining? And if the person just looks at you and says, well, that's nonverbal communication, and that's a statement. And I mean, even think about it. I said, what did he say? This. That's a statement. That's a saying. And you may not think about it that way, but the law looks at it that way. So a statement is that broad. Excuse me. And then it has to be made by a declarant. Who's a declarant? A declarant is someone who's not in court, right? If you are a testimonial witness, you're on the stand. A declarant is out of the court completely. Important note to understand: a declarant and the person on the stand can be the same person, and I'll go into that in a little more detail here in a few minutes. But just kind of think about it for a second. The person who is actually testifying in court can also be the declarant in a hearsay statement, meaning they are technically not in court for the purpose of that statement. Very, very unique way of thinking. It's a very precise way of thinking, and I'll touch on it here in a little bit. And it's offered for the truth of a matter asserted therein, meaning whatever the statement is, that the light was red, if that's what the saying was, then you're producing it for that purpose of saying the light was red. The fact that it is red, it was red. Now, that means you can actually get away with using a hearsay statement, what would be considered a hearsay statement, if you're trying to use it for some other purpose other than the truth of the matter. So, for example, someone's walking down the street and they yell out, "Look out! A slippery step there," right? The person slips. They try to sue the establishment who owned the steps for negligent upkeep of the stairs. And let's say that the attorney for the establishment who owns the stairs and all of that, they get that person who said, "Look out, it's slippery there," to come in and testify to that statement. And you might be going, "Well, wait a minute. You're going to introduce that statement for the fact that the steps are really slippery." No. What we're going to introduce that statement is that the victim, the person who fell, slipped, and busted their head, had noticed that it was slippery. So they were in fact negligent in some way. And that's going somewhere else, but what it means is we're using it for the effect on the listener. Another example would be, "Look out, he has a gun." doesn't mean it necessarily has to come in for the truth of the matter. It could be for the effect on the listener or the state of mind. That is a common example used for self-defense. If I am in a position where I'm pleading self-defense, I can bring someone in to say I was using self-defense because someone out there yelled out he has a gun, and I mean, that's not coming in for the truth of the matter. It's coming in because I believe that there was someone that had a gun. My state of mind. So it's my effect on the listener, and that's not hearsay. So anyways, it's a statement made by a declarant, offered in court for the truth of the matter asserted therein. Now, there are some exceptions, as you are aware of, but I want to make sure that we catch the overarching exception, the thing that's going to capture everything. Even if it meets an exception, if the hearsay statement is not allowed in, but then we find an exception that allows it in, we have to then ask, well, whether or not the Sixth Amendment right to confront a witness, to confront the testimony against you, is implicated. And if you look at your book, and I want to kind of detail this a little bit more than what I've done in other lectures, if you look at testimonial hearsay, and you read on page 248 what it talks about, testimonial hearsay. Testimonial hearsay is inadmissible for constitutional reasons. It violates the defendant's Sixth Amendment right to confront the witness. If it's testimonial, I don't care if there's an exception to the hearsay rules that allows it. The fact that it's testimonial means that it's not allowed to come in because it violates my constitutional rights. It violates the defendant's constitutional rights. We have to remember the rules of evidence are statutory. The Constitution is the supreme law of the land. It reigns above statutes. So if the Constitution says the statute is unconstitutional, then regardless of whether or not you can abide by the statute, that doesn't matter because the Constitution says you can't do it in that way. So understand, testimonial hearsay, regardless if you find an exception, is not allowed in. Specifically, what is testimonial hearsay? And if you look at the second paragraph, that's part of that block quote there from Hammond versus Indiana. It says, statements are non-testimonial when made in the course of, I'm going to say, interrogation or investigation under circumstances objectively indicating that the primary purpose of the investigation is to enable police assistance to meet an ongoing emergency. And the flip of that is that when the primary purpose is for the prosecution of a crime, to establish or prove past events potentially relevant to a later criminal prosecution. A criminal prosecution. So the idea is whether or not there's an ongoing emergency. Help, 911, there's someone at my door. That's to mean an ongoing emergency. If the person leaves, that that initiated the need to dial 911, if that person disappears and the police come and then they say, well, do you know anything about the person? Depending on the timing and everything, it may no longer be an ongoing emergency, especially if the person making the statement is safe and sound. That's a big indicator right there. If the person is safe and sound, and it's unlikely that the person who created the need for a 911 call is no longer to be found, may no longer be an ongoing emergency. So just understand that. If there's an ongoing emergency, it's not going to be testimonial. If there isn't one, it's going to be testimonial most likely. That's it's not always determinative, like it's not that clear sometimes, but just know that's usually what it comes down to. So if it fits into those categories, then it's going to keep the hearsay out even if you find a hearsay exception. Now, the Sixth Amendment doesn't apply all the time because usually it's only going to apply if it's being used against the defendant. Sometimes it's not always being used against the defendant in that way. So if we're in that situation, what can we do? Well, we need to use some exceptions. We have quite a few. Your book goes through just a couple, but just be aware that I've heard a lot of different numbers. There could be as low as 23 exceptions, and there could be as many as 37. I've heard them in all different ways and seen them in all kinds of different sizes. And just understand that regardless if they're 23 or 37, they're all capturing the same thing. And yes, we had to learn them all for law school, so be aware of that. They're not that hard to remember once you kind of understand their purposes, but there are a lot. We're going to go over the select few your book has kind of chosen that I think are relevant for what you're going to need. The first thing to understand when it comes to establishing a hearsay exception is understanding whether or not the hearsay exception you're going to use requires the declarant to testify on the stand, or it doesn't matter whether or not the declarant is available. They call it available unavailability. But when I say available, I'm going to try to also say testify on the stand, because that's what I really mean. And that's what I mean by, that's in reference also to earlier when I said the declarant can be the person testifying on the stand at the same time. One of those situations where the declarant has to be available is an excited utterer. I mean, not whether or not the defendant is available, is for something called the prior inconsistent statement. Now, this is not really hearsay. It meets the definition of hearsay, and we call it non-hearsay, but I want you to understand that it's hearsay. It meets the definition of hearsay. We're just going to pretend it doesn't exist as hearsay. And a prior inconsistent statement requires, one, the defendant to be on the stand, or the declarant to be on the stand, the person who made the statement on the stand. We also require that they're subject to cross-examination, and that that the previous inconsistent statement was given under oath. Those are the three elements. A prior consistent statement is another example of this, except it's a little bit different, right? A prior inconsistent statement is you're testifying here today to A, when earlier you stated in this earlier hearing where you were under oath and subject to cross-examination, you testified to B. So we're going to let B in because it's inconsistent what he says here today in A, and we're going to let B in for the truth of the matter asserted therein. Prior consistent statements are different in that you don't have to be in a prior proceeding where you're under oath and subject to cross-examination. You just have to be subject to cross-examination today, and that prior consistent statement can be made at any point in time as long as it was made after some sort of circumstance where someone made the alleged or accused the declarant, the person testifying on the stand, and also the person who made the statement, that they were lying or they fabricated their testimony. So that timing is very important. Another thing, well, actually, let's move on to where the declarant is unavailable. That's usually the big one, big areas for criminal cases, because usually we want to get in the evidence of some sort of victim. And usually the victim's testimony in a homicide case is very important, because if we can extract that information straight from the victim's mouth, well, then that can be pretty damaging evidence, especially if it's a dying declaration. Dying declarations require the defendant to be the declarant unavailable. To be a dying declaration, to be used in a criminal court, it has to be a homicide case, and the declarant actually has to die, which is kind of harsh, but that's the rule. And then on top of that, the additional requirement that the statement was about the impending death. But it can be about anything as long as it's about the impending death. Usually it's about the cause of death. You know, the defendant shot me, the defendant killed me, I can't believe I'm dying, this, that, and the third. And as long as it applies to the defendant's death, then we're going to let it in as dying declaration. A couple other ones, declaration against interest. This is commonly confused with the statement by party opponent, which is usually a statement of admission. It's some sort of admission. I want you to understand it's not really used that much because we just use the statement by party opponent, but it's there. It's usually the idea that you wouldn't have said the statement if it went against your monetary interest, your penal interest, anything of that nature. So you wouldn't have made that statement because it went against something inherent with you. It may not be criminal, or it may not be incriminating, that's a better word to say, but it doesn't matter really, because we'll just use the statement by party opponent. That way we don't have to prove the declarant is unavailable. That creates an unnecessary step. Now, what happens if the declarant is available, but we don't want to put the declarant on the stand for whatever reason? Competency, they refuse to testify, they plead the fifth, something of that nature. We have quite a few exceptions. Some of the big ones that are going to be touched on, first is the excited utterance, second, present sense impression, and the third one is mental and physical state of mind. I talked about mental and physical state of mind earlier, right? I heard someone say, they have a gun, right? I can testify to that statement not for its truth of the matter asserted. I can testify to that statement for the fact on me. But what happens if I want to testify to something I said about my own physical or mental state of mind? Something, oh, my shoulder hurts, oh, I have a headache, right? I can say, if I say these things, they can later be admitted into court regardless if I want to testify or not, or if I'm available, because they relate to my then existing mental or physical state of mind. And it has to relate to that. It has to be existing. I can't say something about the future. I can say something about my future plans, but I can't say something about a future state of mind or future physical condition. And I can't say something about the past either. It has to be existing. My shoulder now hurts. I now have a headache. I could also say I have plans to meet my aunt so-and-so in the future. That is an existing mental state of mind. And that can come in regardless if I want to testify or not. We'll get someone else to testify to it as long as they have personal knowledge of my statement. Excited utterances, it's defined as a statement made under the impending stress of an ongoing condition. Well, that's pretty much it. I mean, just to summarize it, that's basically it. And the statement has to be caused by the impending condition, right? If there's a lion running across the street, and you go, oh my God, there's a lion running across the street, right? That's an excited utterance. Oh my God, they have a gun. That's an excited utterance. These are things, but it has to be made under the stress of the exciting event. So you can't say, oh my God, they have a gun, but the dude, you made that statement 15 minutes after the person who had the gun ran away. It all depends. There are some unique circumstances, one of them, being the unfortunate situation of rape. 2 hours can go by and the victim can still be under the impending stress of that and make a statement relating to it, and it could be considered an excited utterance because, generally speaking, we consider rape to be a very damaging, stressful event that you can make statements about for a very long time after it occurred. The other one is the present sense impression. It's commentary. That's what it is. It's describing an event or condition as it's ongoing. This is almost like the excited utterance, except there's not a causation requirement between the statement and the stressful event. Commentary is a really good example because you can always, hear, baseball's a better example than football because with football there's a mixture of excited utterance and present sense impression. With baseball, just describing the game as it's ongoing, on the 3-2 count. Pitcher throws a fastball right down the middle. That's present sense impression. There's no excitement whatsoever. Just describing the game as it's ongoing, that's a present sense impression. Now, I mentioned this a few minutes ago. Let's wrap up here with statement by party opponent, adoptive omissions. A statement by party opponent, at the end of the day, if I'm, somehow criminally implicated because of this lecture, you guys could submit all my statements regarding this lecture into court. It would be hearsay, but it would be considered not hearsay because I said it, and therefore we're just not going to give it the name hearsay. But it's hearsay, and it's considered an exemption, not an exception, but exemption. It fits into that same category of prior consistent statements, inconsistent statements, those categories. But that's statement of a party opponent. But what I want you to understand is that sometimes that exception also captures this idea of an adoption omission. And I want you to understand that adoptive omission because it kind of can implicate the right to remain silent. Let's say, for example, you're a police officer and you're conducting a basic beat. Just, walking around downtown Kaiser doing a beat. Now, I know that doesn't exist. Trust me, I know. But you're walking around and you see a couple people talking, and you're just sitting there taking it all in. One of them says with the two people sitting there, one says that the other one committed a crime, and that person doesn't say anything. And in fact, maybe they start walking away. Because of that, because a reasonable person probably would have spoke up in that situation, you can use his silence against him. Because he wasn't in custody and he wasn't being interrogated at the same time, you can use that silence against him because it's considered an adoptive omission. And it's an adoptive omission by silence. So it comes in the same way as a statement by party opponent. And it's kind of interesting because the person remained silent and didn't say anything. So you would think that it might violate the right to remain silent, but it doesn't either because the person wasn't in custody and wasn't being interrogated. The person wasn't even seized. So be wary of that and understand that you can do that. If you're a police officer and you're conducting a beat, you're just walking around, you're hearing stuff, and you're engaging in regular community activity. Whatever you hear, if a reasonable person should have spoken up, you can consider that adoptive omission. Just a little trick. There's nothing wrong with it. So with that being said, that's all I have for Chapter 9 on hearsay and its exceptions. If you have any questions, please let me know, and I look forward to seeing you for Chapter 10.